Now, there's a type of subdivision out there called a condominium. Condominiums are subdivisions. In fact, sometimes they're called vertical subdivisions. Condominium ownership is a situation where you own the airspace rights to your unit, and then through the homeowners association, you own an undivided interest in the structure of the facility, the land, and all the common elements like swimming pools or lobbies and that kind of thing. If there's 29 condos, there's going to be 30 tax notices. One tax notice for each condo unit, and then one tax notice to the commonly owned association property. So it's a true subdivision. Every condominium has recorded in the public record of the county where it's located a condominium declaration. Those are the rules that pretty much made the condo. There's management rules called bylaws, and the bylaws regulate how you use your unit, and those aren't public. You have to get those from the homeowners association. A stock co-op is a little different kind of situation. Stock co-op is not a subdivision. In a stock co-op, what you have is a situation where you have a corporation that owns the whole building, and then you own stock in the corporation. Now, because you own stock in the corporation, the stock that's maybe tied to Unit 10, you're given a proprietary lease. So proprietary lease and the word stock co-op need to be tied together in your head. Utah has a mechanics lien law that allows people that have improved a property to put a lien on it if they're not paid. The only people that can use the mechanics lien law are general contractors, subcontractors, material suppliers, and laborers. Also, occasionally on the test, you might see architects and engineers. But those are people that actually did work on the property. Real estate brokers and agents have no business trying to use mechanics lien law to enforce their commission. We did nothing to improve the property. Therefore, you're not protected by this law. Mechanics lien law is a statutory right. It's only there because of the state law. And, of course, it is involuntary. Now, what happens is a person that improved a property has to give a bill, and then the homeowner has 30 days after they received the bill to pay the bill, and then if they're in default, then they can run down and put a lien against the property. The way these liens are enforced is only by foreclosure. If it's a residential property and they put a lien on that property, it doesn't necessarily mean you're going to get their money. They have to foreclose within 6 months. If it's commercial, they have to foreclose within 1 year. If money is gathered by a foreclosure, subject to a mechanics lien, then the person that gets paid first is the little guy. That would be the laborer. The next person paid, if there's any money left over, would be the subs and material suppliers. And the last person on the totem pole would be the general contractor if there's any money left over. Mechanics liens are assignable. You can never put a mechanics lien on government property. And if a lien was put on a property and then paid off, the person that put the lien on the property must get it off within 10 days after being paid, or they're subject to $20 a day liquidated damages that can accrue until the lien's actually canceled. If you're going to sell timeshares in Utah, you don't need a license. All you need to do is register with each development you're working on. Water law in Utah is very interesting. People fought and died over water in the state. Littoral rights are rights that you have if there's coastal or tidal waters, like on the ocean. Do you own to high tide or do you own to low tide? Well, you really only own to high tide. It looks like you have a lot more land when the tide's out, though. In our state, we don't have any lands like that or waters like that here in the state of Utah. So prior appropriation is how we divvy up land and water here. See, in a lot of states, we have riparian water law. And riparian water law says if you own the dirt, you own the water. But Utah, we use prior appropriation, which means someone probably got there before you, and all really great water rights are from the 20s and 30s. All water is owned by the state of Utah, but it's divvied up under a concept called beneficial use, and we use the concept of prior appropriation as well. Beneficial use means that the highest use of water in our state's agricultural, and then commercial, industrial, and then last culinary or drinking water. Culinary drinking water doesn't use that much water, though. These other uses use a lot more. The people that sort out all this mess is the state engineer's office, and they have a division called the Division of Water Rights. If you're trying to figure out who owns what water rights, you go to the Division of Water Rights, state engineer's office. If you're just trying to figure out where they're getting their water from, then you go to the county recorder's office and you look up the well permits. The state engineer also has responsibility to control and regulate geothermal development in the state, if you have hot water under your land. And we have a few places like that. There's something called water rights that we've just been discussing, and that's real property, therefore be transferred with the deed. And then there's water shares. Now, water shares are personal property. They're like shares of stock in an irrigation company that owns the water rights. Water shares are personal property and therefore transferred with the bill of sale. Water table is the level of subterranean water that might be in a particular area. And then we have situations where we have percolating water. Perk tests are very important if you're going to put in a septic tank. You have to make sure that the septic will actually percolate and not contaminate the water table in that area. And then lastly, in Utah, we have one minor use of riparian water law, and that is for boundaries. If, for example, you had a deed that said you own everything up to the Missouri or Mississippi, those are big rivers and can be used for commercial purposes. You only own to the water's edge. We only have two bodies of water that could be used for commercial purposes in Utah, and that's Utah Lake and the Great Salt Lake. All other water bodies like the Green River or whatever river, the Virgin River, if your deed said you own to the Virgin River, you actually own to the middle of the river. Those are boundary issues in regards to water law in Utah.